Esteemed attendees, distinguished guests, ladies and gentlemen, welcome back. Now let us commence with the final session of the 12th Asia Pacific ADR Conference titled, Your Money in the Digital Jungle. What does it mean to you? Now, you know the rules. I would like to first invite our distinguished moderator and speakers of our final session to the stage. So if you're serving as a moderator or a speaker, could you please rise and take your designated seats on stage? Ladies and gentlemen, please welcome them with a big round of applause. In session 4, the Honorable Mr. Leung Sun Chan, Senior Counsel and Chartered Arbitrator at Duxton Hill Chambers will serve as a moderator. And we are joined by 4 speakers, including Mr. Duncan Speller, partner at Wilkie Farr and Gallagher, and Mr. John Chung, partner at Freshfields Brookhouse Derringer, and Mr. Mike McClure KC, partner at Herbert Smith Freehills, and last but not least, Mr. Sean Long, equity partner at Winners Worldwide. Now let me give you a brief introduction of our excellent moderator. Mr. Chan is a senior counsel of the Supreme Court of Singapore, and he is a chartered arbitrator practicing with Duxton Hill Chambers. He is also a member of the ICC Commission on Arbitration and ADR, and in addition, he served as the global head of arbitration of an international law firm in the past, and also he served as president of the Singapore Institute of Arbitration or Arbitrators. And finally, he is the deputy chairman of the SGX Appeals Board. So without further ado, let me hand over the microphone to our distinguished moderator. So ladies and gentlemen, please welcome him with a big round of applause.
Thank you very much. 안녕하세요. 초대해 주셔서 감사해요. Now, out of respect to my Korean friends, I'm going to continue in English and not to torture them anymore. This last topic is actually one that has been trending, and we talk about digital assets such as cryptocurrencies and NFTs. Although they exist in the virtual environment, they have real value to us in the physical world. And the virtual environment is not a mere playground, because it is serious business. The question is, are rights in digital assets enforceable? What have been some of the cases that we have seen that have come up in relation to digital assets? Today, we are fortunate that we have 4 very knowledgeable panelists who will share with us their experience. And I would just like to briefly introduce them, because this session is going to be interactive in the form of question and answers. Questions from me, answers from them, because I have no answers. Okay. I'll start with Mr. Duncan Speller, immediately to my left. He's global co-chair of Wilkie's arbitration practice group based in the London office. He's an English barrister with more than 20 years experience of international arbitration. Duncan has been involved in multiple disputes involving digital assets, including disputes relating to the collapse of FTX. And to Duncan's left, we have John Chung, who is head of Freshfields Hong Kong and mainland China arbitration practice. He's a chartered arbitrator with extensive experience handling cases throughout Asia. This has included Korea-related arbitrations, including those in the crypto and fintech space. Next to John, we have Mike McClure, KC. He's a partner and a King's Counsel based in Herbert Smith Freehills, London office. Mike regularly contributes to the broader arbitration community in Korea. He used to stay here, after all. In 2019, he received the Korea Arbitration Award from the Korean Ministry of Justice in recognition of his contributions. And next to Mike, we have Sean Leong. He's an international arbitration specialist and equity partner of global law firm with us. He was previously a magistrate and assistant registrar of the Supreme Court. And I've actually argued cases before him as well. Now, Sean recently became the first lawyer in the world to successfully obtain a worldwide proprietary injunction to freeze a non-fungible token on the blockchain in a commercial dispute. What I would like to do is to ask the panelists a number of questions that will perhaps tease out the issues that can arise in relation to digital assets. And to start off, maybe Duncan, you can tell us or give us an introduction on what are digital assets.
Good afternoon, everyone. It's a great pleasure to be back in Seoul and to see many familiar faces. And thank you to the organizers for bringing us together and presenting such an interesting issue for discussion. What are digital assets? As I was thinking about this question the other night, I was watching CNN, and there was an interview with a man called Michael Lewis, who's just written a book called Going Infinite about Sam Brinkman-Freud and the FTX collapse. And he was asked very similar questions. And he sort of said the possibilities are infinite, hence the title of his book, as to what a digital asset is. But I will briefly address, firstly, in layman's terms, secondly, in terms of the jurisprudence we have, what are digital assets? Well, in layman's terms, an asset is something of value, be it contractual or proprietary, and digital means comprised of data, particularly binary numerical data. And we have, for example, NFTs, which are identified distinguishers on a blockchain or a disclosed database that provide a means for certifying ownership. So we have, in relation to what digital assets are, both a public element, the blockchain, and a private element, the key to the network address or the piece of data. But in layman's terms as well, the scope of what digital assets comprise is broad. In legal terms, we've actually had quite a bit of jurisprudence over the last 4 or 5 years on what exactly digital assets are. For example, in the UK, in 2019, there was a judicial task force led by Sir Geoffrey Vose, the Master of the Rolls, which looked at, in particular, crypto assets and smart contracts. And that task force issued a paper that concluded that although digital assets don't necessarily fall into historic categories of property, they have certain indicia of being property, in the sense that although they are digital in form, they are something that can be identified to a third party and that can potentially give rise to proprietary rights. And there have been a number of cases that have affirmed the proprietary elements of digital assets and formed that they can be the basis of proprietary remedies. I mean, one of the leading cases is the decision of the New Zealand courts in New Roscoe and Cryptopia, which confirms that digital assets can form the basis of a trust. So we have these assets, these things of value, comprised of data that don't fall into existing legal categories of what property is, but in many jurisdictions a growing jurisprudence which confirms that they can be the subject of proprietary rights and remedies.
Duncan, thank you very much for the introduction. I think as we go along with the panelists' contributions, there will be some illustrations of the broad principles that Duncan has identified. And perhaps you can start with the question, what kind of disputes can arise in relation to digital assets? John, would you like to kick off on that?
Sure, Ling Sun, and a very good afternoon, everyone. It's also lovely to be back in Seoul. Certainly the weather helps a great deal, but especially this wonderful audience here, so thank you very much. So I think, Ling Sun, your question for me is what kinds of disputes are we seeing in the crypto space? I think the short answer is we're seeing an increasingly broad range of disputes, and I'll illustrate the broad waterfront, as it were, with a couple of examples, the categories of disputes we're seeing. So first, and these are probably the disputes you see the most in newspapers. fraud, misappropriation type claims involving crypto assets. So your classic story is where someone's come along and stolen the private key and, as it were, obtained possession of a crypto or digital asset. But these tend to fall more in the litigation realm rather than in arbitration. So it's of somewhat less interest to us right now, although there have been attempts to pull in the crypto exchanges, for example, into these disputes. And of course, there are arbitration provisions in agreements with a number of crypto exchanges. So that's the first category, your fraud or misappropriation type case. Somewhat closer to home, mis-selling claims. So there you are seeing various claims being brought against developers or crypto exchanges, typically and often in the context of insolvency claims. And I think Duncan touched on this somewhat. So these arguments revolve around, for example, alleged breaches of regulations protecting consumers. And we've certainly seen an uplift of these cases in the last 1 or 2 years as a result of the crypto winter that we've been seeing in the industry. So mis-selling claims, that's the second category. The third category, something I think much closer to home and much more traditional to us lawyers here on the panel, are your classic claims involving, for example, share purchase agreements, where the underlying asset might be shares in a crypto business, or even crypto assets that were transferred, for example, off-chain. So you have claims of that nature, or investor agreement claims, joint ventures involving crypto assets, service agreements, for example, disputes over service outages that can have an impact on one's ability to trade crypto assets. So cases of that nature fall under the third bucket, what I would call slightly more traditional realm of cases. And lastly, financing disputes. So, for example, it is quite often and common really in the crypto industry to see collateral being granted, security granted over digital crypto assets. And again, then you have disputes over how you enforce these security rights. So that's a quick canter through a couple of broad categories of the types of disputes that we've been seeing.
Thank you very much, John. And I think, Mike, you have some examples that have actually gone before the English courts as well. Do you want to add to any of these illustrations?
Yeah, so sort of the other side of the disputes we're seeing is the crypto world is creating a lot of issues that we need to think about as arbitration practitioners from the enforceability perspective. And I have a few examples, including from the English courts, of some perhaps slightly surprising enforceability-related decisions that should be on our radar when we're thinking about discussions concerning crypto assets. So I'd sort of rank them in order. Perhaps sort of one of the sort of more least surprising assets or issues. In certain jurisdictions, certain forms of digital assets, particularly cryptocurrency, is illegal. A big jurisdiction is China, and there are concerns about whether you can enforce awards relating from crypto-related disputes in China. And there was a case from 2018 where there was a dispute, and arbitration took place within China. But then enforcement of that award, and it was all about payment for certain payment due for certain Bitcoin. The award was rendered in the Chinese yen equivalent, so it was an award for a monetary sum. But nonetheless, the court in Shenzhen refused to enforce that award on public policy grounds, even at its own Chinese arbitration award. I've got another example from Greece that happened last year, where there was an order from an arbitral tribunal for a sum of money to be paid in Bitcoin, and that award was refused to be enforced in Greece on the basis that Bitcoin was not a recognized currency, and therefore enforcement of the award from the non-recognized currency could create issues concerning to sort of tax or fraud. So again, sort of slightly surprising decision, perhaps sort of gut feel to us as practitioners. And then there's been some examples from my own home jurisdiction, the UK courts, where a lot of crypto and digital assets cross over into the realm of users cross over into the realm of consumers, and in many jurisdictions, including in the UK, consumer rights protection in legislation is not arbitrable, and so there have been a couple of decisions from the UK courts last year where, notwithstanding arbitration clauses in the agreements between the user and the platform or the program, that the English courts have nonetheless assumed jurisdiction because the consumer has enforced their rights as under the UK consumer protection legislation. And a particular case that I wanted to draw to your attention is a case from last year called Ceketin v. Payword. Mr. Ceketin was a trader on a cryptocurrency platform operated by the company Payword. Just as a sort of side note and for your amusement, he was a lawyer by training, but he was trading in crypto in his spare time, and perhaps fulfilling the stereotype that none of us are great with technology, he lost lots of money on the platform. The platform tried to collect from him, and under their contract they had a provision for jams arbitration in San Francisco. The platform obtained an interim award from a jams tribunal, and the plaintiff participated in that process, but nonetheless then resisted enforcement of the award against him in the UK on the basis that he was because he was in the UK and he was a consumer, and he was he was purchasing, or he was doing his consuming in the UK, he was subject to the UK consumer protection legislation. And so even there was failure to recognize the award because it's contrary to UK public policy for arbitrations to take place in relation to non-arbitrable subjects like consumer protection. And so it's just, I sort of raise these as things that may not automatically be on all of our radars, but as we sort of talk about the arbitrability of digital disputes and disputes relating to digital assets, there's not just the types of disputes that can arise between the parties, as John alluded to, but it can create problems that we might not necessarily be thinking of at the enforcement end.
Thank you, Mike. Just now, in his opening, Duncan alluded to certain rights in digital assets, contractual rights, proprietary rights. And perhaps we can invite John to see if he wants to expand on that. Is our existing legal framework sufficient to deal with digital assets?
Certainly, and let me pick up on both your question and also Mike's points around essentially some of the unique features, as it were, of crypto-related disputes that we're seeing. And I think before I get to that, the question we're often asked is, well, are crypto disputes really that unique? Are they that special, or are they essentially the same thing in a different container as well? And I would suggest that the reality is there are often elements of a crypto dispute which are actually very familiar to us. And there are other elements of the dispute which are, one would say, special or unique and present various challenges. And this, of course, latter category arises because of the nature of crypto assets and how they're fast mutating and intangible, and that creates a number of challenges which we'll come to. I would say from my own personal experience, the cases I've been involved in, I would say in a number of these cases, 80 to 90% of the case actually raises disputes that are similar to issues that we come across in other arbitration disputes. You might need some industry expertise, of course, you might need experts on certain issues, but by and large, they are fairly standard run-of-the-mill cases. Then there are other cases which are very technical in nature, which impinge on questions such as those raised by Ling Sun around, for example, property rights, and which was also touched on by Mike. Let me give a couple of illustrations. So first, a somewhat simpler example. So I'm seeing quite a number of cases where it involves investor agreement disputes. These, for example, might involve purchase of shares in a crypto business, or a joint venture dispute involving the crypto business. Now, large parts of disputes or arbitrations of this nature are actually fairly standard. You have your usual agreement that's been entered into by the parties. Often in the crypto digital world, they're not that well drafted because they're often drafted in a rush. Parties are in a rush to move things along in the digital world, but still you have a written agreement which provides for arbitration, and you have a dispute over the construction and interpretation of these provisions. You have a dispute over whether shares or the underlying asset has transferred. Those are fairly standard issues that you come across in a whole range of disputes. So those are your run-of-the-mill, fairly more commonplace crypto disputes that we're all familiar with. Then you come to the other cases which throw up unique questions of the kind that we've been talking about on this panel. So let me illustrate it with three particular complexities that at least I've seen in crypto-related disputes. The first is to answer Ling San's question, and touching on something that Duncan had talked about also, is of course the vexed question of property rights. Are crypto assets, digital assets, are they property in nature? But I'll address this question in a slightly different fashion from when Duncan briefly touched on them. The importance of this question is obviously that if crypto assets, digital assets are property, then you do have rights as against all of the world, and you can transfer these rights to other parties. Now, as Duncan alluded to, there's been a great deal of discussion about whether or not crypto or digital assets meet the classic definition of property. Crypto assets, again, a reminder, so they are intangible. They involve cryptographic authentication. They involve decentralized systems. They involve distributed ledgers. So all of these raise various questions as to whether or not your crypto asset falls under your classical definition of a property, which typically is something that's sufficiently identifiable, has sufficient permanence, has sufficient stability. The short answer, and Duncan gave a little bit of a highlight on that, is that fortunately a number of courts, and in addition to those that Duncan had mentioned, those in Hong Kong, those in Singapore, have taken a pragmatic view. And I understand that in Korea, so there's legislation dealing with this. So all these legal systems have taken an approach that crypto assets do, in short, qualify as property. So that partly resolves the first of these three unique features or challenges I've talked about. It does open the door to one being able to create interests over digital or crypto assets. You can impose a trust, a common law trust over it. You can have tracing claims. You can have off-chain transfers of property. You can issue proprietary remedies, as was touched on earlier. Proprietary remedies, as we know, are very important, especially in the crypto space. Interim measures equally so, because crypto assets can be dissipated very quickly. So you want to be able to establish crypto assets are property, and you can get this urgent relief. Still, these are early days. There is still a lot of room for more complex questions around what constitutes ownership of digital or crypto assets. For example, multi-sig crypto assets, where you have multiple keys involving the same asset. How do these different key holders, what is the nature of the relationship with the asset? Do they hold the asset jointly and severally? Do they hold the asset at all? Is there an underlying beneficial interest in the property? Those are some of the more complicated questions that remain to be resolved. But that's the first of the three complications around whether or not it's property. The second one is one which Mike touched on earlier, around legality. So a number of jurisdictions, as Mike mentioned, do not recognize crypto assets as legal tender. Some of them do not even recognize crypto exchanges, such as mainland China, as Mike alluded to. This raises various challenges, and I'll just illustrate this with three quick challenges. The first is if you choose the wrong seat. If the seat doesn't recognize the legality of a crypto asset, you might well have a problem arbitrating your dispute there. The second is if the applicable law is one which doesn't recognize a crypto asset, then you might well have an issue where the underlying agreements which govern your transaction are potentially illegal. That's the second challenge. And the third one is, of course, enforcement. You may not be able to enforce if the enforcing state doesn't recognize your crypto asset. So there are three quick challenges arising from questions around legality. I'll then move on to the third and my final point around, again, unique challenges that you tend to encounter in the crypto space, and that is around how you value a crypto asset. That's been a real challenge in a number of cases that I've come across. And one of the main issues is over the lack of comparables around the crypto asset, and also the volatility of crypto assets in terms of how quickly the price of these assets move. If you have volatility in the asset, then by extension, you have challenges valuing the related crypto businesses and the crypto exchanges, because to some extent, their value depends on the value of the asset underlying it. So a couple of points here. One of the challenges is the lack of liquidity in certain crypto assets, apart from the well-known Bitcoins, lowercase b, that are out there. There are various other crypto assets which are less well established. There are thousands of them out there, as we know, and it can be difficult to value them, especially if your dispute involves a large quantity of a thinly traded crypto asset. A short track record. Crypto digital assets have been with us for only a short period of time. It is difficult, for example, to project future cash flow. The volatility of the asset is something I touched on. This is linked to complex issues such as what is the valuation date you use to value your crypto asset. And that's particularly important where the value of the asset fluctuates a great deal within a short period of time. So you see arguments around, do you value the asset based on the date of the breach, or do you value it based on the date of the hearing? And that time gap can result in a huge divergence in the valuations underpinning crypto. Causation is a related issue there. What damages have been caused by the breach you're complaining about versus what damages flow from general market volatility and fluctuations. And the last point, crypto businesses, exchanges, many of them are decentralized businesses, and that makes it difficult to value. It makes it difficult to identify which is the real component of the business that retains, on which real value resides. And then it's difficult also sometimes to pin down the parent in this entire complex structure that one has. So there you have it, 3 challenges or somewhat rather unique features of crypto and crypto disputes. First, the debate around property rights. Second, legality. And third, the challenges in valuing the underlying asset.
Thank you for that very clear and structured outline of legal issues and special features. Now, Sean, do you have anything to add to what John has said are some of the special legal issues that arise out of digital assets? Because you have dealt with a number of cases involving the assets. So.
Thanks a lot, Links. And I think John has, very adeptly covered, the issues that we have seen, at present. But I think I would like to touch a little bit more about the kind of issues that we should be expecting to see, in time to come in the next couple of years. And, given the huge AI team of, this year's conference, I would like to touch a bit on the increasing interactions between AI technology and Web 3.0 technology or blockchain technology, right? In many ways, I think AI and blockchain technologies, they kind of need each other to bring itself to the next level of operation, right? So we have heard earlier today how in order for AI to function properly, you need to have data, right? And to be honest, there is not a single AI system in this world that is completely unbiased, right? All AI comes with biases, right? Your AI is only as unbiased as your data set, right? And technologies would share with you that in order to mitigate biasness, you need a large volume of data. And where better to get data than in the decentralized blockchain, right? Because the entire impetus, the genesis of blockchain technology, which is a very old form of technology, right? Whereas crypto is a newer development. The very impetus of blockchain technology is to have a decentralized, in fact, cross-border way of storing information, storing records that are immutable and cannot be reversed, cannot be amended, cannot be modified, in a global way, right? And so the amount of data that exists in the blockchain presents a lot of opportunity for AI, to do a lot of various stages of AI modeling to bring AI to a different stage. Now, blockchain, on the other hand, is traditionally actually a very slow form of technology, right? If you go to any departmental stores today, you just wave your credit card, your Visa PayWave, and you get that done. But try doing a digital asset transaction on the blockchain. It's going to take you much longer, right, than simply tapping your card. Now, with AI coming in, it's going to make the computing process, it's going to increase the efficiencies to another level, right? So your movement of digital assets could be magnified, when you implement AI. And already you are beginning to see a marriage of these two technologies in real-world use cases, right? AI has already been used by traditional finance and now are increasingly used by Web 3.0 technologies. For example, John mentioned fraud, for example, is quite prevalent, in the crypto sector. Already businesses are increasingly integrating the use of AI, into their security functions, right? So that if there is suspicion of fraud, a certain wallet would be frozen to preserve the digital asset. AI can also be used to combine real-time live data that you can gather from off-chain information, your real-world markets, combining it with on-chain information, right? And that could be also used, to instruct smart contracts to buy or sell your digital assets depending on market conditions. So, it already is a reality, that crypto digital assets, NFT players are using AI technologies for their operations, right? But what happens when AI goes wrong, right? That's where things start to get interesting, right? And last year, I had the privilege of working on a case, and this actually has some connection with Korea, right? Many of you would know from the news that last year, the world's largest stablecoin collapsed. About 2 weeks after the collapse of Luna, the Luna token, which is 2 weeks from when the Luna token, which is a stablecoin, lost its peg to the US dollar, the entrepreneurial founder, who is South Korean, a technologist himself, somewhat of a mini genius, he created a new token called Luna 2.0, right, very soon after its collapse, on a brand new blockchain, a separate blockchain. Okay, so I had a chance to represent a cryptocurrency exchange in Asia. Now, the exchange had nothing to do with Luna, save for the fact that Luna token was one of the many tokens traded, right, traded on the exchange. And it just so happened that there were a few individuals, right, sitting in front of his or her computers late at night, watching, the volatility, right, and were trading worthless Luna 1.0 with Luna 2.0, which was worth about 0.25 cents in terms of the spot price at the material time, which meant that overnight, they became purported millionaires. So they woke up the next morning, right, realizing that they've become millionaires overnight because, the digital assets in their wallets have increased. Now, that's because purportedly, the trading algorithm powered by AI could not tell the difference between Luna 1.0, which was worthless, and Luna 2.0, which was worth something on the market, right? And so we had to fight, a case of unjust enrichment. We had to apply traditional doctrines of mistake onto mistakes made by a robot. But you see, many people, when they're talking about mistakes made by AI, they would assume that AI was not doing what it was meant to do. But the reality is that many mistakes made by AI was due to the fact that the AI was performing exactly what it was designed to do, save that it could not have the capacity to take into account the black swan events, the curveballs, right? And AI might not know how to handle the collapse of Silicon Valley Bank, and AI may not know how to handle the sudden, acquisition of Credit Suisse by UBS, your real world events, right? So in this case, there was a collapse of one of the world's largest stablecoin. A new coin was replicated, but the AI could not tell the difference. So how are you going to be managing complexities like this, right? And I think the fundamental question for us disputes lawyers is always who is liable? Who should the finger be pointed at, right? And there are various chains of complications when you're talking about businesses who use AI, right? Because whether you are a bank who has a robo-advisor, whether you are a car company with a self-driving automation functionalities, or whether you are in the medical field, right, where you use a robot to perform complicated high-level heart surgery, you may not be the ones who created the AI, right? So I think we got to first start off with the fact that there are businesses involved in gathering the data, and questions are being asked, how do you actually gather the data? Now, when the data is gathered, you need to develop the AI model, right? So a different company might be the ones that have developed the AI model. right? And then you have your algorithm scientist, who's supposed to design the algorithm, right? You have the software programmer, who's supposed to create a software for the AI to run, right? You have the integrator, who integrates your AI, to your businesses. And of course, you have businesses who use the AI without perhaps actually knowing how to maintain the AI, for example, the AI systems, because an old AI based on old data set may no longer be relevant for the current use, right? So across the entire chain of AI development, you could have different people who are at fault, right? And so when we are talking about AI disputes, I think the first question you need to ask is, where do you find the causal blame, right? Where do you find the liability, right? And increasingly questions are being asked, what if I examine the entire chain, right, and there is no human error at all, right? And it is actually the AI that is at fault. And so there is increasing conversation around whether AI in and of itself should be attributed legal liability, just like how companies have, independent, separate legal personality. Perhaps AI, should also have separate legal personality. Thank you, Ling San.
Thank you. Sean, that was an excellent introduction of the technical aspects of AI and digital assets, and that's a very groundbreaking case that you were involved in. You actually raised a very interesting point that came to my mind when the earlier session was under the chatbot known as Kevin Kim was moderating. And basically the question was, should you replace a human adjudicator, human arbitrator with AI? And the point you raise is very relevant because we know that human beings are subject to bias, can be even unconscious bias. And those of you who have read a book by Daniel Kahneman called Noise, really see that there's a lot of noise in judicial decision-making, including arbitrators. And there are a lot of factors that influence us when we come to a decision without us knowing that we are biased. Studies have shown, for example, that sentencing decisions being handed out in the US would vary wildly from judge to judge, and even within the same panel, you could have different decisions on whether they had breakfast or had lunch. So should you then replace that with AI on the idea that AI, a machine, would be infallible? But as Sean has illustrated, AIs can be fallible. In fact, there's a UK Law Society report in 2018 called Horizon Scanning, where they talk about how trends would affect the legal profession in the future, in particular AI. And no doubt that there are many studies that show that AI can outperform actual lawyers, real lawyers, when it comes to gathering data, analyzing documents, and predicting outcome. Certainly on that aspect, they can outperform human beings. But as the Law Society report also pointed out, do you want to entrust decisions to AI because there's a lack of transparency in how the AI works? Even their programmers, as AI becomes even more complex, cannot really explain the algorithms that had actually generated the decision by AI. So AI can be subject to algorithmic bias, just as human beings can be subject to our own biases. And that's why I put up my hand when Kevin asked who would still want to have a human arbitrator. Because Sean made the point, can you trust a machine because it's garbage in, garbage out, right? You are trusting an unknown programmer who has used data unknown to you and how they prioritize information that goes into a machine that ultimately decides your fate. So I digress a bit, but coming to Duncan, because Sean has talked about a few high-profile collapses of platforms and digital assets. Duncan, I believe you were also involved in one case. Do you want to talk about that as an example of the kind of lessons to take away?
Certainly. Certainly. Well, John set down three challenges posed by digital assets and the evolving legal framework. I'd like to propose 4 lessons learned, essentially from my role in advising on rights and remedies in connection with the collapse of FTX. And these, in a sense, reflect that many of the common legal concepts apply to digital assets, but because of the nature of the asset, the issue can emerge in slightly different ways. The first lesson is the need for clarity about what the asset is and when ownership is relinquished. As we've discussed, digital assets are intangible. The record on the blockchain is an indication of ownership, but ultimately a key signifier of ownership is control of the virtual password. So who actually owns the asset and at what point in time can be fundamental both in terms of rights and remedies. As we've discussed, a lot of cases involve insolvency, and whether there's a ownership right can have a significant impact on priority and insolvency. It can have a significant impact on rights and remedies, whether a party can invoke proprietary rights and remedies such as injunctive relief or trace the asset. So my first lesson is sort of clarity as to what the asset is, and for the owner not to unknowingly relinquish the asset by, for example, surrendering the virtual password to a third party who then may say they have legal ownership of the asset. The second point that I would say is an important lesson learned is the interplay between trusts and ownership. That there's been a string of case law saying that you can have a trust over a digital asset. That's a decision of the New Zealand courts in New Roscoe and Cryptopia. But one of the issues that's emerged in the case I looked at is a question as to whether the intention of the parties was to create a trust. There were indications pointing in different directions as to whether the parties actually created a trust. In this case, the original owner of the digital assets had relinquished legal ownership to FTX. The issue was whether they had retained beneficial ownership through the creation of a trust element. And so the second lesson learned is the importance of clarity in terms of whether the intention is to create a trust. To have a trust, you need the 3 certainties of intention, object, and subject matter. And here, because of the indications in different directions, it wasn't entirely clear whether a trust had been created. So it's important for parties using digital assets and relinquishing legal ownership of digital assets to be clear when they are seeking to create a trust relationship and when they're not seeking to create a trust relationship. The third and related point is the contractual framework. In many cases, there is an underlying contract in relation to the digital asset. For example, FTX had terms of service with the owners for which it acted as custodian. So that created contractual rights and remedies. At one level, contractual rights and remedies are weaker than proprietary rights and remedies, and that they can't be invoked against the whole world, and you don't have the same right to seek proprietary relief. But it's important that the contractual framework is consistent with the intent of the parties as to who holds ownership of a property and whether there's any trust. One of the issues that arose in the case I looked at was that, again, there were interlocking contractual terms that in some respects were inconsistent with the apparent intent of the parties in terms of whether they intended to create a trust. So I think it's important that parties are clear as to what contractual rights and remedies they intend to create and how the contractual rights and remedies interrelate with proprietary rights and remedies. the fourth and final lesson is beware hidden liability risk. I mean, there's lots of unknown, lots of uncertainty as the application of known legal concepts to new assets. An example of the risk of hidden liability is an English case, Tulip Trading and Van Breyer, where there was an argument before the English Court of Appeal that the operator of Bitcoin owed a duty of care to the public at large because of the foreseeable risk of loss. And the first instance court rejected that. The Court of Appeal held that it was arguable that the Bitcoin operator did owe a duty of care. That presumably wasn't a liability risk that was in their mind at the time they entered into the legal relationships, but is a liability risk that has emerged as at least arguable through the application of known legal concepts to new asset types. And to some extent, Sean touched on this in terms of his idea, should AI have liability in the same way, legal identity and liability in the same way that, that a corporation does? And these are sort of relatively untested areas that arise from trying to fit new assets into the prism of existing legal concepts. And I think it's important for parties to be aware of liabilities that may emerge in tort, in addition to proprietary rights and remedies, trust rights and remedies, and contractual rights and remedies.
Thank you, Duncan. John mentioned just now that one of the things that people should look at when they are entering into contracts relating to cryptocurrencies would be the question of whether those contracts will be enforceable. And in particular, we know of only one example in China, where the courts have refused to enforce an award that granted certain reliefs in relation to a contract for the mining of cryptocurrencies. But quite apart from that, it does bring to mind a very important question. Cryptocurrencies and blockchains and so on, they do not exist within the physical jurisdiction of a country. So what conflict of laws issues might we be grappling with when it comes to these digital assets? Mike, do you want to give it a go?
I'll just end up asking more questions, but it's another very, very sort of hot topic and issue for us to think about, particularly in relation to some of the platforms that have no express agreements about governing law. You then have these platforms going out across the world, touching several different jurisdictions, and then it creates conflicts of law issues about which laws, which governing laws do you apply. The approach of the English courts so far has been to try to find the location of the asset, and it's done that by determining the place of residence of the owner. There's some logic to that approach, but obviously it creates huge issues as well. First of all, these platforms touch many different jurisdictions, so just because that's the way the English courts look at it doesn't mean that will be the way courts in other jurisdictions will look at it. But secondly, also, even applying that English law analysis, the users of these platforms will be in several different jurisdictions, and so it would expose their platform to conflicts of laws and governing law issues, touching sort of a whole host of jurisdictions. The easiest way to sort of navigate this is with good, well-written contracts and some form of governing law provision inserted within them. But without that, it can create a huge minefield when you're starting your dispute, and obviously a huge area for conflict and dispute. There's currently actually a number of consultations ongoing in relation to this very topic. So there's one in the UK that's being commissioned by the English Law Society. There's another one being run currently by UNIDROIT under the United Nations. But looking at that exact issue as to which governing law should apply in relation to the cross-border cryptocurrency and digital asset exchanges.
Thank you. Duncan, I believe you also spoke about this topic, and you mentioned something about jurisdiction and choice of law. Do you want to expand on it?
Certainly. I mean, I think the first point is that this is an area where there is huge uncertainty at the moment, perhaps more uncertainty than in relation to the substantive rights and obligations. I agree with Mike that the traditional proprietary conflict of law analysis is not easily applicable to digital assets because it looks for a lex situs, and what is the lex situs of an intangible asset such as a digital asset. Mike has mentioned the UNCITRAL task force and various other investigations into this, but at this stage we don't have an established set of conflict of law rules in the same way as we do for contract, for tort, where there are established rules and conventions in terms of applicable law and in terms of the allocation of jurisdiction, such as, for example, within the context of the EU, the jurisdictional regulation. So there is huge uncertainty. Secondly, I agree that as a result of that uncertainty, it is even more important for parties to make express, clear provision for what governing law they intend to apply and to what jurisdiction they intend to opt into. One of the issues in unraveling the rights and obligations in relation to FTX has been that you have had many different contracts with different jurisdiction provisions in tension. And that has created huge uncertainty as to what the best forum is. It creates the opportunity for a claimant, to some extent, to claimant shop by sort of invoking the most favorable forum. But at the end of the day, the question of enforceability arises. My third and final point relates to the relative advantages and disadvantages of arbitration. A great advantage of arbitration in the context of disputes concerning digital assets is the New York Convention. That if you obtain an arbitral award in one jurisdiction, that is presumptively enforceable across borders pursuant to the New York Convention. And indeed, in the FTX saga, a number of the relevant contracts, for example, provided for arbitration seated in Singapore. The downside of arbitration, though, in terms of asserting proprietary rights, is that, of course, an arbitration typically only binds the parties to it and won't bind the rest of the world. So that can be sort of one disadvantage of arbitration. So I think there's a need to kind of focus on what exactly the right, be it proprietary or contractual, you're seeking to vindicate is, and what the best forum for that is at the time that the relevant legal relationship is entered into. And of course, as with all disputes, at the end of the day, the objective is enforceability. The objective of the dispute resolution provision is to ensure that any determination as to the parties' rights and obligations is binding and enforceable.
Thank you. And that is indeed a key question. How do you enforce rights? And if you go to court or go to an arbitration, at the end of the day, you're not just talking about theoretical rights, you want to enforce it. And I wonder, Sean, if you have something to add to that very important and practical topic.
Thanks a lot, Ling San. So we all know that an international arbitration award can be globally enforceable under the New York Convention, in over 150 countries all over the world. But we also know that public policy, right, is one of the classic grounds, enshrined in the New York Convention, which allows an award to be refused enforcement, right? And we have heard from my fellow panelists today on how across the world there are varying treatments of crypto, right? If you look at the Middle East, for example, we all know that Emirates, the blockchain business is flourishing in the Emirates. But if you cast your eye across different countries in the Middle East, you'll find that actually in some countries, they have absolutely banned crypto, right? Perhaps, having the perception that it's in violation of Sharia law. In China, for example, Mike has shared with us the Shenzhen case, where the Shenzhen court refused to enforce an arbitral award. Now, this is because of the local mandatory laws in China, right? The Chinese establishment, rightly so, would like to, protect, its national currency, and so it has very strict laws to prohibit the conversion of fiat or real world currencies into crypto, and vice versa, right? And so the Shenzhen court uniquely took the perception that if you have an arbitral award, and as arbitrators are very used to issuing awards, ordering the payment of monies in real world currency, right? So if you have an award ordering a party to pay in real world currency, where the initial obligation that arises is in crypto, that is perceived by the Shenzhen court as trying to use the arbitral process to convert cryptocurrency into real world currency, right? And so from that court's perspective, that award was not enforceable. But I think the better view is actually held by the Shanghai Intermediate People's Court, because in Shanghai, there was a decision, right, where the court took a different perspective. In that case, which I personally feel is the better view, cryptocurrency was not perceived to be a form of currency or legal tender, right? Because Chinese laws expressly say it is not legal tender. The Shanghai courts held the view that cryptocurrencies could be perceived as a form of property. And so when the arbitrator orders an award, ordering someone to pay in, say, US dollars, what the arbitrator is doing is not converting crypto into USD, but actually trying to ascertain the value that ought to be compensated for the loss of property, right? So I feel like that is a better view. And the Shanghai courts actually held that an award ordering payment in real world currency could be enforced in China, right? But I think the critical point is that in fighting, in being involved in, crypto disputes, you need to have a complete strategy, right? It's not just about the arbitration, it's also about the enforcement, right? And the losing party, the party who loses the arbitration, could strategically withhold a key weapon to use later on, right? For example, if the laws of country X, for example, the laws of country X says crypto is outright banned, right? At the arbitration, I may not adduce the law of country X. I may not be able to, because the law, the dispute that is being arbitrated is governed by the law governing the substantive performance, which is usually, the contractually agreed law. So the law of country X may not be relevant. So I say nothing about the law of country X, and if I lose, and the successful party comes to country X to enforce, I can bring in the laws of country X to say you cannot enforce against me because of illegality, right? Because of public policy, right? So, in other words, when you are engaged in a cross-border dispute, it is necessary to consider not only the merits of an arbitration, but also a strategy towards enforcement. Just last week, the United States, released a new set of laws to prevent the export of advanced computer chips for use by Chinese businesses involved in AI, right? So if you are involved in a crypto dispute where the crypto client is using AI functionalities, you may want to seriously consider to what extent can any award arising from that dispute be enforced in the USA, for example, right? So that's a recent example. But what I've shared so far is only about the legal challenges of enforcement, but I want to quickly touch on the practical challenges on enforcing an award against digital assets as well. We know that there are people in the Web 3.0 world who would do anything they can to hide, their crypto assets, right? So, for example, people do use privacy tokens or privacy coins, right? Number one, to encrypt the chain, the movement of the digital assets on the blockchain, so that you cannot see, where the digital assets is being shifted on the blockchain. Another use of privacy tokens, for example, is in mixers, right? So you mix your real digital assets with fake digital assets together, so that the real transactions can be disguised, right? So, there are players in the crypto world who can be very savvy at doing this, right? So that presents a real practical challenge in enforcing an award, right? So there are companies who have AI capabilities who can de-encrypt, the code that you use to encrypt and hide your movement on the chain. There are also AI functionalities who can unmix, using complex algorithms, unmix what has been mixed, right, in terms of digital assets. The other scenario that, disputes lawyers in this, with experience in crypto disputes would probably experience is that, even if you win an arbitration award against the counterparty disappears, or the counterparty refuses to obey the award, right? The attitude would be like, touch me if you can, right? The digital assets is in the amorphous realm of the blockchain. You can't get to it, right? Traditionally, if you win a decision, all right, and you know that there are monies in a bank, you can seize the monies, right? With a freezing order, you can have an attachment order. If there's real world properties, right, real estate properties, you can seize those assets, but how are you going to seize, your digital assets that lie on the blockchain? And so, increasingly, arbitral institutions from around the world are considering, having a unique set of rules for crypto disputes where parties agree, by incorporating those rules, that at the outset of an arbitration, both parties hand the keys to the smart contract to the arbitrator, right? So in the UK, you have the digital disputes resolution rules, right? They actually recommend a mechanism like this, right? So if there is such an agreement and the counterparty refuses to hand to the arbitrator, powers over the smart contract, it is possible to go to the local courts to get a compulsive order, right, on pain of committal possibly, against the counterparty to hand the keys over to the arbitrator at the start of an arbitration, so that if you have an award, the arbitrator would decide, please hand the digital asset over to the winning party. The arbitrator himself or herself would have the ability to modify or amend the smart contract to move the digital asset from the losing party's wallet to the successful party. And in the interim, it can be held in an escrow wallet that is custodized or administered by the arbitral institution, right? So that is a possible way to mitigate the challenges in enforcement against digital assets. Thanks, Ling San.
Thank you very much, Sean. So certainly the law has a lot to do with catching up with the way that these blockchain transactions work, and how either fraud or even theft that Duncan mentioned earlier on work in the virtual environment. So the Singapore courts, for example, have already ruled that it's possible to serve documents by social media, because you do not know who stole your cryptocurrencies, for example. And you don't even have to identify the person by name, because you don't know the name of that person. You can just identify by description. So the law is not exactly up to date, but it's trying to catch up. Now, John, I'm going to give you the joker card, the wild card, because you've been quiet for a while. Do you have anything to say in response to any of the points that your fellow panelists have raised?
Well, that's at least fortunately a rather open question.
Limited to 3 minutes rather than 30 minutes.
No, that's difficult. Yes, so I have been actually listening. It did occur to me that one of the features of arbitration that's interesting for us, because there's been a great deal of discussion around property rights. One of the benefits and trade-offs of arbitration is, of course, that a lot of the arbitration disputes obviously are founded upon a written contract. where you can have, and usually would have, your arbitration agreement. And as Mike alluded to, you would also have a choice of governing law. Now, in that sense, actually, we deal with the easier part of this whole debate over property rights, because for purposes of an arbitration, you're primarily only concerned with the governing law that applies as between the contracting parties. And so you can use the mechanism that, for example, Mike alluded to, where you try to control the potential governing laws or applicable laws that come into play by defining what the governing law is in your contract itself. But bear in mind that there's an element of that that's outside the control of arbitration, which is, of course, third-party rights. And that, in some ways, is the real value that exists in the crypto asset. It's not necessarily or only the ability to enforce your rights as against your counterparty to the contract, which you can by means of your governing law, which you define in the contract. But of course, it's the ability to enforce those rights as against the rest of the world, the entire world. And that's where I think the property law question and choice of law question really comes into play, because the challenge is in your contract as between you and the counterparty, you've defined the governing law that governs your rights, inter se, as between the parties. But this choice doesn't constrain third parties who are not parties to the arbitration, and they may well argue it's a different law that applies. It could be the one, the domicile of the holder of the asset, for example, which Mike alluded to, which some of the English cases have gone with, or it could be some other fantastic law that is far too complicated, or something of that nature. Now, in some ways, in the arbitration world, we're quite fortunate because we avoid having to grapple with a much more complicated question. But at the same time, I think it underscores the weakness of arbitration in the sense that your decision is only as between the parties and isn't necessarily a decision as against the rest of the world. And of course, a decision as against the rest of the world is really important in the context of crypto assets.
Thank you. I would now offer similar opportunities to the other panelists. They have shared actually quite a lot. And one thing that they have done very well, I think you'll agree, is that despite their huge amount of knowledge and their experience in this area, they have been very obediently keeping to the time or the chess clock that I had imposed. But maybe I can just offer them if they have 1 or 2 minutes of closing remarks. Duncan, do you have anything?
Related to John's point, I think one area where there's a need for greater certainty is the position of a third-party bona fide acquirer of digital assets. What happens if you acquire the virtual key in good faith? Why should you be bound by whatever contractual obligations, whether in terms of an arbitration clause or otherwise, someone else has entered into? And I know the Law Commission, who've recently published a paper in the UK, propose introducing, as a matter of statute, a substantive defence where a third party acquires an asset in good faith. But I think there's also the question of what jurisdiction provisions also apply in that case. Do you look at the jurisdiction of the bona fide third party, or do you look elsewhere? And I'm sure in time there'll be discussion and emerging jurisprudence on that issue. But I think currently we're in a situation where, as you say, the legal solutions do perhaps trail the technology.
Thank you.
I'll just take one more minute,
Sure.
a quick plug perhaps. So potentially what you might need is, of course, a New York or a Seoul convention on the governing law of digital assets, really, to resolve this challenge, because otherwise, you need something equivalent to that, arguably, rather than a patchwork approach to it.
Yeah, and just something for me, maybe I'll follow that up too. Sean alluded to in the UK, there's this thing called the DDR, the Digital Dispute Resolution Rules. We're seeing other arbitral institutions sort of try and tweak their rules to focus on potential disputes that can arise out of digital assets. Notably, JAMS in the US has some draft rules specifically dealing with disputes with digital assets, which have tight time periods and in particular sort of rules about how discovery will work, and experts appointed to explain the blockchain. But nothing is sort of finalized yet. There's certainly no sort of best practice. And so, in addition to the forthcoming Seoul Convention on the enforcement of digital arbitral awards, I laid down a challenge to the arbitral institutions, KCAB perhaps could lead the way on the arbitral rules as well.
So, Ling San, I was actually going to save a controversial comment for if I have additional time. So, you know, if you borrow money from a bank to buy a house which you have no money to pay for, your bank can actually go to the court to get a sheriff, you know, or court bailiff, go to your house, break your lock, chain up your house, you know, and lock it up, right? So I always ask the question, why can't we do the same for digital assets, right? And I studied at least the Singapore Rules of Court. Now, the Singapore Rules of Court allows the court to engage third-party professionals to use force for enforcement purposes, right? And so there is this increasing perspective that, you know, perhaps the court one day, well, maybe it's the UK courts, Hong Kong courts, or Singapore courts, or Korean courts, one day would, in order to assist in the enforcement against digital assets locked up in a wallet, engage hackers, digital security experts to hack into a wallet by force, right? To retrieve the digital assets and give it to the proper owner. I think that's at first instance is controversial, but it might just happen. Thanks, Lim.
You know, just before COVID hit us, and I always said this during the COVID years, that Korea and KCB had been prescient had incredible foresight, even though they couldn't have foreseen COVID, in coming up with a remote hearing protocol. So they had a standard for remote hearing even before COVID hit us. And by the time COVID hit us, suddenly there was a starting reference point. And of course, other institutions came up with their own protocols after that. So picking up from what John and Mike had said, well, maybe Korea, it's time for you to work on cryptocurrencies and digital assets. A set of rules, you know, maybe it cannot cover everything, but we shall see. That will be your project, probably. Now, we have a few minutes, but I don't want to take up more time because we have Professor Chang's closing speech, which I'm sure we are all eagerly awaiting. So I will end here and thank the panelists for your excellent insights. Thank you.
So that brings us to the end of our final session. And for us to listen to Professor Chang, we have to rearrange our stage. So I'd like to ask our panelists to go back to your seats and remain seated. So ladies and gentlemen, please give them a final round of big applause. Thank you very much. Well, thanks to their innovative insights, we could enjoy yet another round of constructive discussions. And the title was Your Money in the Digital Jungle. What does it mean to you? And I'm sure we all know by now what it means to us. And finally, please remain seated just for a while because we have one final task to perform. And once the stage is ready, we are going to do our final act and then you're free to go. Thank you very much. And if you're joining us online, please stay tuned.